There is a line no defendant should ever cross in a courtroom, an invisible boundary that separates poor judgment from criminal contempt. Once that line is crossed, there is no apology that can fully undo it, no explanation that can erase what's been said. I've seen angry defendants shout. I've heard threats from people who believed they were powerful, but I had never seen anyone cross that line the way Barron Trump did. It happened on a Thursday afternoon. Barron Trump stood in my courtroom, looked me directly in the eye, and threatened me with White House connections while his father was still the sitting president of the United States. I have been on the bench long enough to recognize empty bluster. Defendants promising revenge, claiming they know people, insisting I'll regret my rulings. Most of it is noise, fear talking through anger. But this wasn't that. This was different in a way that made the room feel colder the moment the words left his mouth. Barron Trump was 18 years old, the son of the President of the United States, surrounded by Secret Service agents, backed, whether explicitly stated or not, by the full weight of the executive branch, and he was telling me that if I didn't dismiss his charges, his father would make phone calls and I would regret it. That is not bravado. That is a threat to the judiciary itself. The case before me had begun like many others, at least on paper. Barron was being tried as an adult and stood accused of assault, destruction of property, and underage drinking. According to police reports and witness statements, the incident occurred at a house party in Providence, hosted by a Brown University student whose parents were major donors to the Trump campaign. Alcohol was flowing freely. The party was crowded. At some point, another guest, Michael Chen, a 19-year-old Brown sophomore, accidentally spilled a drink on Barron's designer jacket. A few drops, nothing more. Michael apologized immediately. What should have ended there did not. Barron punched him in the face, breaking his nose. When Michael tried to record what had happened, frightened and bleeding, Barron grabbed his laptop and threw it against a wall, destroying it completely. The laptop contained Michael's schoolwork, his projects, months of effort wiped out in seconds. Witnesses described Barron yelling about money, status, and power, about how much the jacket cost, about how no one could touch him. Those facts alone made the charges serious, but what transformed this case into something unprecedented was not the assault itself. It was what happened after I denied his attorney's motion to dismiss. Barron stood up. He brushed off his attorney's hand when they tried to stop him. He didn't look nervous. He didn't look afraid. He looked confident, certain that what he was about to say would work the way it always had. He told me his father was the president, that presidential power could make or break people, that judges could be picked and unpicked, that I needed to understand who I was dealing with. In that moment, I realized this was no longer just a criminal case. It was a direct challenge to judicial independence, a test of whether the courtroom would remain a place governed by law or become another room where power speaks louder than justice. And I understood that whatever happened next would not just affect one defendant. It would define whether the line that protects our democracy still mattered at all. When Barron finished speaking, the courtroom went completely silent. Not the ordinary quiet that follows a heated exchange, but the kind of silence where everyone understands that something irreversible has just happened. I could feel dozens of eyes shifting between Barron, his attorneys, the Secret Service agents, and me, waiting to see whether the threat had landed. I kept my voice calm. Deliberately so. Before we address your criminal charges, I said, we need to address what you just did. You stood in my courtroom and threatened me with presidential retaliation if I do not dismiss your case. Do you understand the seriousness of what you just said? Barron stood there, all 6'7" of teenage arrogance, shoulders back, chin raised. He didn't hesitate. He didn't retreat. Your Honor, I'm not threatening you, he said. I'm stating facts. My father is the President of the United States. He's the most powerful man in the world. He protects his family. You're deciding right now whether you want to be someone he protects or someone he doesn't. That was the moment I knew he truly believed it. Not just believed it, but had been taught it. His lead attorney, Theodore Lawson, jumped to his feet immediately, panic flashing across his face. Your Honor, my client is 18 years old and speaking under extreme stress. He didn't mean I cut him off. Counselor, your client meant exactly what he said. He just threatened a sitting judge with presidential retaliation in open court. On the record. Sit down. I turned back to Barron. Mr. Trump, I'm going to give you one opportunity, to retract that statement and apologize to this court. If you do so now, we will proceed with your criminal case in the ordinary course. If you do not, I will hold you in contempt and will add witness intimidation and obstruction of justice to your charges. I watched his attorneys silently beg him to stop. They shook their heads. One of them mouthed the word, apologize. The room held its breath. Barron looked at them. Then he looked back at me. "I'm not apologizing," he said. "You heard me correctly." And then he went further. He told me his father runs this country, that his father picks judges and can unpick them. He reminded me I was an elected municipal judge in Providence, Rhode Island. He asked if I really thought I mattered, if I really thought I could touch him. Then he issued an ultimatum. "Dismiss the charges," he said, and he would walk out of the courtroom and we would all forget this ever happened. If not, his father would pick up the phone. The courtroom erupted. Reporters began typing furiously. Barron's attorneys put their heads in their hands. Secret Service agents started speaking urgently into their radios, clearly untrained for this kind of moment. This wasn't a security issue. This was a constitutional one. I sat there, absorbing what had just occurred. A sitting president's son had openly threatened a judge with executive retaliation. Not behind closed doors, not through intermediaries, in open court, on the record. This was no longer about an assault at a party. This was about whether the judiciary could function independently when directly confronted by presidential power, about whether intimidation would succeed simply because of who delivered it. I stood up slowly. And in that moment, the future of the case and the meaning of the line Barron had crossed became very clear. I stood up slowly, not because I was angry, but because the moment demanded clarity. When a courtroom reaches a point where the rule of law itself is being tested, hesitation becomes its own kind of failure. "Officer D'Angelo," I said, "place Mr. Trump under arrest immediately for criminal contempt of court, witness intimidation, and threatening a judicial officer." For a split second, Barron didn't react. The confidence on his face froze, as if his mind was trying to process words it had never expected to hear directed at him. Then the shock hit. "What? You can't arrest me. I have Secret Service protection." I turned my attention away from him and toward the agents positioned along the walls. "Agents," I said, "your responsibility is to protect Mr. Trump from threats to his physical safety. You do not protect him from lawful arrest for crimes committed in open court. If any of you interfere with this arrest, you will be charged with obstruction of justice. Step aside." The lead agent hesitated. I could see it in his eyes. This was not a scenario covered in training manuals. He spoke quietly into his radio. The room held its breath. 30 seconds passed. Then he stepped back. "We will not interfere with lawful judicial proceedings," he said. "We'll remain nearby to ensure Mr. Trump's safety while in custody." Barron's confidence shattered completely. "You can't do this," he said, his voice rising. "My father's the president. He'll what?" I asked calmly. "Use presidential power to interfere with a criminal prosecution? That would be obstruction of justice, potentially an impeachable offense. Is that what you're threatening now?" His attorney jumped to his feet, demanding an immediate recess, saying the situation had escalated beyond reason. I denied it. "Your client threatened a judge with presidential retaliation," I said. "That is a crime. He is being arrested." Officer D'Angelo approached Barron carefully. "Mr. Trump, please place your hands behind your back." Barron looked around desperately, scanning the room for someone, anyone, to stop what was happening. "Call my father. Call the White House. They can't do this." I looked at him directly. "Mr. Trump, your father cannot help you right now. You committed crimes in my courtroom. You threatened the judiciary. You are being held accountable." As the handcuffs clicked shut, the transformation was complete. The entitlement, the certainty, the belief in immunity, all of it collapsed in an instant. "This is illegal," Barron shouted. "You're violating my rights. My father will hear about this." "I'm counting on it," I replied. "Because your father needs to understand that presidential power does not extend to threatening judges. And if he attempts to interfere with this prosecution, he will be the one facing constitutional consequences." Barron was led toward the holding area, still shouting that I was making the biggest mistake of my life, that the Trump family doesn't forget. The door closed behind him and the courtroom fell into stunned silence. I turned back to the defense table. "Counselor, your client has now threatened this court twice. Once could be dismissed as reckless immaturity. Twice establishes a pattern. I am remanding him into custody without bail pending psychiatric evaluation." His attorney protested, citing his lack of criminal history, his age, his family status. I stopped him. "Your client is a flight risk with unlimited resources. He has demonstrated contempt for the judicial process and openly stated his belief that executive power will interfere on his behalf. Under those circumstances, bail is denied." I turned to the prosecutor. "Contact the Rhode Island Attorney General immediately. Also contact the FBI. Threatening a judicial officer and invoking presidential interference raises serious federal concerns." Then I addressed the Secret Service one final time. Mr. Trump is now in the custody of the Rhode Island Department of Corrections. He will receive protection, but no special treatment. He is subject to the same rules as every other inmate. Is that understood? The agent nodded grimly. At that point, it was no longer a question of what Baron Trump believed power could do. It was about what the law was required to do, no matter whose name was on the docket. Once Baron was removed from the courtroom, I took a moment before continuing. Power had just been confronted head-on, and the law had answered. But the case was never only about threats to me. It began with a victim who had been quietly waiting while a constitutional crisis unfolded around him. I turned to Michael Chen. He had been sitting still the entire time, his nose still bandaged, his hands folded tightly in his lap. I asked him to come forward. As he approached, the contrast was impossible to ignore. An 18-year-old college student, slight in frame, standing where moments earlier the son of the president had stood making demands. I apologized to him, not for the ruling, but for the fact that the focus of the courtroom had shifted away from the harm done to him. Then I asked him to tell me what happened at the party. His voice was quiet but steady. He explained that he was a sophomore at Brown, studying computer science. The party had been crowded, music loud, people moving everywhere. He was holding a drink when someone bumped into him and a few drops splashed onto Baron's jacket. He said he apologized immediately and offered to help clean it. Baron looked at him, Michael said, and asked if he knew how much the jacket cost. Then came the punch. His nose broke instantly, blood everywhere. When Michael tried to record what was happening because he was scared and wanted proof, Baron grabbed his laptop and threw it against the wall. It shattered. 2 years of work, gone. Michael's voice cracked when he said the words that stayed with me. Baron told him his father was the president and that nobody could stop him. I looked at the empty chair where Baron had been sitting. I told Michael that what happened to him was wrong. That assault, destruction of property, and intimidation are crimes, no matter who commits them. And that despite everything that had just occurred, justice would not be lost in the noise of power. Then I turned to the prosecutor and instructed her to formally add the new charges. Contempt of court, witness intimidation, threatening a judicial officer, obstruction of justice. Because what had happened in that courtroom was not just criminal behavior. It was an attack on the Constitution itself. Within an hour, the story had spread nationwide. A president's son arrested in open court for threatening a judge. Cable news panels debated separation of powers. Legal scholars weighed in. The White House issued statements. But inside my courtroom, none of that mattered. What mattered was this. The line had held. In the weeks that followed, Baron Trump pleaded guilty. He received a reduced sentence, restitution was paid to Michael Chen, and the constitutional crisis quietly ended when cooler heads finally understood the stakes. No phone call came, no pressure worked. The system did what it was designed to do. 1 year later, after the presidency had ended, I received a letter from Baron. He wrote that he had believed power meant immunity, that he had learned the hard way that it does not. He thanked me for holding the line when no one else had. I placed the letter in my desk and returned to the bench, because in America, judicial independence is not optional, it is not negotiable, and no matter how powerful the name, no one, not even a president's son, stands above the law.